I hope you're all thinking last but not least, although,
Save the best for last.
yeah, you save the best for last would be better. Yeah. So last night I got taken for a heart-pounding ride in a convertible with the top down, and the advantage of that is it really woke me up, right? So I want you all to imagine you're with Dory Ann in her convertible going fast, and your heart is beating, because I know everybody's pulse has slowed down as the day has gone along. So I need to start quickly. I'm not going to waste time thanking Buffy and Kate, because they know how grateful that I am. I do want to start with just a little story, though. I went to the University of Virginia as a new assistant professor in 1981, having heard the word mediation 2 years previously and thinking, gee, this would be a good idea to do some research on, since I was concerned in some of the work I'd done about conflict in families. And I was fortunate enough, I hadn't never been at a university where there was a law school before. There happened to be a law school at Virginia, you may have heard of it. And fortunate enough to get introduced to a colleague there who was really interested in custody and family law, who's sitting here today, Buffy Scott. And one of the very first things that Buffy did is, and this is probably in my first year as I was just starting this new work, is she handed me 2 papers to read. I had never been exposed to law before. One was Mnookin, 1975. The other was Mnookin and Kornhauser, 1979. Pretty damn good introduction to family law. Now, actually, we're going to come full circle with this, because if you remember this morning, Buffy was saying she's had to copy the Mnookin 75 multiple times because she keeps misplacing them. Well, here is her original copy. And here it is, right? But since you've had all these other copies, you're not getting it back. But I swear, you look, this is her original copy. So, right. So reading these articles started for me a love affair with the law. But I want to be clear, I said it this morning, Bob thought I was playing the country lawyer's game. That it is an affair I have with the law. It's illicit, right? I am married to psychology. I know what I'm doing in psychology. I'm just kind of fooling around over here. And so that's my way of disclaiming anything that I say wrong. I'm just having some fun, and I'm going to try to say some things that are provocative, and I'm really looking for you to fill in some of the gaps about the law. So, no doubt, it's been said, Jana has drank the Kool-Aid. That's, the mediation Kool-Aid. There's no doubt that Best Interest Standard has set up the need for dispute resolution. I'm just quickly going to say, think about how far that's gone. So this is a little funnel I drew in my paper. I use this a lot in my talks. And the idea with a funnel is you want to settle most of the cases up here at the big end and fewer cases down towards the narrow end of the funnel. And so you have up here things like pro se divorce and negotiating the kitchen table. This is why I wrote a book for parents to help them to work things out themselves, to divorce education, to mediation, collaborative law, which really hasn't been mentioned today, but another exciting thing. Attorney negotiations, there's room for them. Child advocates like guardians ad litem. Custody evaluations, I made the argument quickly that they are really a form of de facto arbitration. Well, actually, in parts of the country, more and more custody evaluations are being used explicitly for arbitration purposes. You do a quickie custody evaluation, you make a recommendation, the idea is to get people to settle. I think that's what's always been going on anyway in these more formal custody evaluations, even though some custody evaluators really treat it like they're really discovering the truth about what's best, as if that existed. You go on down through judicial decision-making. Finally, I want to mention something. I'm going to talk a little bit about something I just started doing recently myself, parental coordination, a MEAD-ARB process, generally reserved for high-conflict repeat litigation cases where you do mediation, you try to help these people to work really important issues out, like this is what I'm working with now, does your 16-year-old really need a babysitter? The parents disagree. They've been had judicial decisions about this repeatedly about whether they need a babysitter or not. We're talking about this, and then I make the decision if you're going to be such, we'll get to that. So a whole range of things, and this is all about trying to get these things settled, in part because there's no law, and also I like to think in part because if parents can work this out on their own, it's going to be, to use a term, in their own best interests in the sense of they're going to have to be working with each other and with their child afterwards, after all this thing is done. So it's not only getting cases out of the court, solving this incredible problem for the judges, but I think it's also in the family's best interest. I have over here, just to show you, this is something Bob would be familiar with, except it's upside down. This is your conflict pyramid turned upside down. It should look like a funnel, except I couldn't get the graphic to draw it that way. But he showed in his study with L&CP that, in fact, an effective court works exactly like that funnel looks like. Along the way, it's just one of these things, working in this area, it's like I grew up in a really small town, and I find that this area is like a small town, academics interested in families and custody, it's a small town. And in one of my travels around, multiple times actually, I've run across the judge whose court was presiding in the court, who you studied, Len Edwards. And he said, "That's my court you're talking about." So he's made it to the slide. So it does, some of you know I've done work on mediation, randomized trial, and it does actually not only resolve cases out of court, but it actually helps parent-child relationships, helps keep non-resident parents connected to their kids. I follow these families over a course of 12 years. I've talked about that forever. I'm not going to talk about that again. So, to continue the affair theme, why not go all the way, right? Why not treat separated parents more like we treat married parents? A few years ago, I was invited to contribute a paper to the Wake Forest Law Review and worked on it with my wife, and started researching something that I read vaguely in some other law review article, what really goes on, and that is that courts have refused to hear disputes between married parents. And I want to read to you this ruling, 1936 ruling in Sisson v. Sisson in the New York Court of Appeals. It reads like a advocacy piece for mediation. Dispute between parents when it does not involve anything immoral or harmful to the welfare of the child is beyond the reach of the law. The vast majority of matters concerning, is anything beyond the reach of the law? Maybe, The vast majority of matters concerning the upbringing of children must be left to the conscience, patience, self-restraint of father and mother. No end of difficulties would arise should judges try to tell parents how to bring up their children. Only when the moral, mental, or physical conditions are so bad as to seriously affect the health or morals of the children should the court be called upon to act. So there's the child protection exception, right? Reads like an advocacy piece for mediation. It's the justification for not getting involved in married parents. This is why my wife, who is a lawyer, cannot sue me. And if she was allowed to, she would, right? Absolutely, right? And as it turns out, courts throughout the country have repeatedly refused to hear these cases, right? So why, now, in 1936, this would probably be a silly question to ask, why not, apply the same rule to parents who are getting a divorce, but, move forward, whatever, 80 years, and you have 50% of marriages ending in divorce. You have 41% of children born outside of marriage, and they're eligible for custody hearings. You have cohabiting relationships that are even more likely to break up. Why do we think that judges should be making decisions for about half of parents in our country today, but not be making them for the other half? So it's a thought experiment, rhetorical question, but the more I play with this idea, it doesn't seem as crazy, although I'm sure to Suzanne it seems completely crazy, and we'll hear about that in a second. I also think, the why that you typically hear is, because parents are bringing a dispute to the court. That's why we get involved in these cases. But if that's the case, in writing this paper, it made me think, if it's purely because you're bringing a dispute to court, why and where did this come from? And this is my question, really, where did this come from? That if I don't have a dispute, if we agree, where then do judges get the authority to overturn my agreement? And I've had many judges ask me, because I speak with judges, how do I know when that joint custody agreement isn't going to work so I can overturn it? It's like, and they're like, no, don't do that, right? But there's some judges who think they want to do it. Where does that authority come from? Somewhere the child protection idea has snuck in to override what you tell me was just purely a dispute resolution issue, because there's no dispute. We agree, yet I have that authority. Where does that come from? I don't know. I haven't run across that idea in the legal literature. So tell me the answer to that. Okay, some specific things. I'm not really thinking that we're going to put lawyers out of business. Although I have to, if I can tell one little anecdote towards the end of the day, I have to say to Bob's comment at lunchtime, but resolving disputes is a pretty important thing, and yes, I think that is, and I'm not trying to get rid of lawyers. Although one of my favorite articles ever was Russell Baker, who I don't know if you remember, used to be a columnist for the New York Times. In the 1980s, he wrote an article that a funny article that I really loved. That was in the 80s when we're having all these panics about Japanese cars coming into America, and they're going to swamp our economy a little bit like we're concerned about China. And the punchline of Baker's article is, why don't we swap cars for lawyers, right? We'll export lawyers, we'll trade them. So I'm not really looking to do that. But if you think about some issues about if we limited judicial authority, gave parents more authority to do a few things like there's no automatic judicial review if parents agree, and I think that's ALI had said that. We honor and enforce parent contracts, and in part of that, we don't need to worry about the justification of alternative dispute resolution because we're really giving parents of all categories authority to make decisions about their kids as long as they agree. What would that happen? It would clearly lead to fewer court cases, as Bruce has shown, and as Bob's data has shown from earlier on. It would encourage innovative alternative dispute resolution. So here, this comes back to the parenting coordinator idea. I have a parenting coordinator agreement that says the parents agree to give me authority to make all decisions about their kids if we move from mediation into arbitration. Is that a valid contract that the parents have just signed? Can they actually contract around their child's best interest? I think the answer is no, they can't, right? But wouldn't it be interesting if they could, and what you do is you work it out with the judge somehow illicitly, I don't know, extends their authority to you. And so you can do it in practice, but I don't think it's really been done. If you do that, if you allow parents to contract around that, you open the door to all sorts of possible dispute resolution, going back to some of your wise elder ideas that you played around with in that paper from 40 years ago. Even from a silly notion, maybe some practical things come out of it, like actually how you delegate this authority and who you delegate it to, and there may be better people out there to do that. Or another issue that comes up all the time, and I'm going to stop talking in about 2 seconds, is can parents do something that I want them to do that I've written at length about, which is to construct a living agreement that's developmentally appropriate that gets out of the issue of what do you do with a baby? Because if you have a baby and parents are fighting about the baby, of course the father's lawyer says you better fight for time right now because if you delay for 2 or 3 years, you're going to be in a really bad position. The mother's lawyer says you better fight right now because you're breastfeeding, you're sympathetic, and so on. So what do? They fight. But if they could write a enforceable contract with all the limits that I don't know about on enforcement and blah, 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 that said, we agree that we're going to construct an evolving plan so this is going to happen, and that's enforceable, and your lawyers aren't rightly telling you that's an unenforceable contract. No, it's explicitly an enforceable contract. I think that would be a good thing and solve another problem. So this kind of crazy thought experiment of treating single-parent families more like we treat married families maybe isn't so crazy after all. And I think I have one more thing to say. Who knows what's best for children? Their parents. Married parents make mistakes too. Divorced parents will make mistakes. But maybe we do a better job of helping them if we let them make the mistakes along with mostly the best, decent decisions that they do make.
I'm feeling a little pressure that on the last one on the agenda, either Buffy or Kate tell me there's going to be some formal remarks after I get through. Even though, I don't know. That puts pressure on me to be profound, and I don't think I can do that. Because what?
You just set your own bar.
Well, I'm going to fail. But I say that because this has been absolutely terrific. What a high it has been all day to be here. Bob, I teach contracts in family law, and in both of those, I manage maybe not every class, but most classes at some point to use bargaining in the shadow of the law. And my colleague, with whom I've written several times now, Ralph Peoples, teaches all the ADR courses, and he says bargaining in the shadow of the law almost almost every class. So Wake Forest law students, no bargain in the shadow of the law. I don't know that we always give you credit. We don't give you proper attribution, but they do know the phrase. And if Bob, what was your phrase? You just mess around in the law? You mess around so well. So here we have from Bob the ultimate answer to the problem of indeterminacy. We'll just kick the bastards out. No lawyers, no judges. The nuclear option. Bob's given us the nuclear option today, which I guess doesn't seem so radical as the day has progressed. As we've all said, yeah, best interest of the child sucks, but what are we going to do? So maybe he's not so radical. And it doesn't look as radical I think he's just provoking us, knowing he was coming to a room full of lawyers. But it's not as radical when you look at it, that his funnel, that we are looking at all kinds of dispute resolution mechanisms, starting with the kitchen table, and then go into mediation. I will say a word about mediation. Ralph Peoples and I, along with Catherine Harris in the sociology department at Wake Forest, wrote a law review article based on an empirical study back in 2002. We collected a lot of data and analyzed it, and I really expected to find, though my collaborator said, you don't even think what you're going to find, just let the data speak to you. But I couldn't help it. I expected to find, because North Carolina is a mandatory mediation state, and that's one of the reasons Bob loves us, is that we're a mandatory custody mediation state, and I expected to find that there would be more shared parenting coming out of mandatory mediation than it did in other settings, other mediation states that weren't mandatory, but it wasn't true. There wasn't more shared parenting coming out of North Carolina, is what, if the data we looked at, which was one county, one representative county, we thought. So I was, in the writing of that article, I felt like I was kind of living with Bob, because I looked so much at his wonderful work on mediation. But we have changed our attitude, I think. We lawyers have changed our attitudes about mediation. We love mediation now. We love it. Lawyers in North Carolina love mandatory mediation. But I think it's very important that North Carolina is one of those confidential states. I think Bob disagrees with me about that. So I'd like to, when you respond, I'd like you to say something about it. Because it seems to me, if you were what Bob calls muscle mediation state, that if the mediator is then going to report to the court, that you've really cut off the rest of your kinds of mediation, the parenting coordinator and all the rest. We're going to have the mandatory mediation. If that doesn't work, we're going to go to court and make the judge is going to make you do what the mediator recommended. So I'd like for you to speak to your preference for muscle mediation. And then I think we almost got into it last night, because I was so interested in his reference to what the law is when the family is intact. That, sure enough, you're exactly right. If you're just messing around with the law, you've got it exactly right. That in the intact family, the judge is not going to intervene. We've got even more cases. I mean, the one we always teach is McGuire v. McGuire, which you may be interested in seeing, but it doesn't have kids in it, so never mind, you wouldn't be interested in it. But we engage in this fiction, and believe it strongly, it's got policy behind it, that if the family is intact, that family's better off if the state stays out. The state stays out in the form of judges being able to make decisions about kids unless it falls to the child protective area. But we abandon that when the family's no longer intact, or has never been intact in the case of kids where the parents have never lived together. We don't. We say exercising its police power, we will no longer engage in this very strong presumption that they are acting in the best interest as long as the family's intact. But once that family is not intact, then we believe that the state has a role to play. And I was telling Bob last night, I'll say it the first day of class, because the first day of class in family law, we're talking about how the state stays out and that state acts best that acts least as far as the intact family is concerned. And I say, watch this principle when we get to divorce, because boy, are we going to turn it on its head. But that's why we do. And I don't think we're willing to shake that. I think we lawyers, the law, have faith in that's operated pretty well, that we don't act when the family's intact, but then after it's no longer intact, then we jump in both hands and both feet. And you said a couple of times in your article something I think I take issue with, that we think that parents are going to act in the best interest of their child, or going to make their feeble efforts to do it, and that those people don't look any different from the people that end up litigating custody. And I just have the instinct, it'd be nice if I had data, and maybe you could give it to me that you have this data, that I think those people are different. You know, what percentage is it? Bob, your percentage was less than 2%, actually end up bringing their case to a judge. And I just have to think that those 2% are different. In ways that mean I'm not ready for the nuclear option, and saying that the courts have got to stay out altogether. But I do think I loved your focusing our attention on the enforceability of agreements, parents' agreements. I think we're ready for that. North Carolina, for example, has now written into its guidelines, and I'm not sure how much this is true in other states, written into its child support guidelines that a judge must enforce the child support agreement unless it finds it unreasonable. And I think we're ready to say that about child custody agreements too, that you must enforce it unless, put a high burden, unless you find it unreasonable. Same thing for parenting agreements. The judge has got to do that. So I think you've brought a really good point to our attention. Even the enforceability of a contract to turn it over to the parenting coordinator. I think we're ready to find those agreements enforceable, and that you'd have a high burden to prove that it was an unreasonable thing to do. So you've given us great things to think about on that point. I don't think I'm ready to say the same standard that applies in the intact family applies when the family's no longer intact, but you can come up and tell me why I'm wrong.
Actually, I want to say just real quickly, one of the nicest things about coming here is, because I know most everybody else, and that it's great to see everybody else again, but one of the nicest things is getting to meet you, Suzanne, and I'm a real admirer of your work, and I feel really simpatico, which is great. One thing I'd like to know, so what is the theory behind the state's need to supervise people who aren't married, right? And I need, help me to understand that theory, okay?
Once they're fighting between themselves, then they've got a conflict of interest. The child becomes a potential pawn between their own interests rather than their primary shared commitment.
So married parents don't do that?
Married
Right.
parents can get divorced. Divorce is a safety valve. If you say no legal adjudication between parents who are divorced, what happens if they can't reach agreement? I mean, one of the justifications for the state not intervening in the intact family, at least in modern times, is that if a wife is unhappy about the husband's level of support, she can divorce him. But in your world, what is the safety valve for those parents who can't solve their problems?
I suppose they could go and seek outside help, the outside help of a problem solver, right? I'm not sure. I need to, with this limited time, I don't want to just focus on that. I need to read up and that's really a legitimate question. I need to understand that theory, because I haven't, it's not written there a lot.
Sophie has it
I've
exactly
written,
right, though.
Yeah.
and I've written about in our marriages relational contract article, we have a sort of an explanation about why there isn't legal enforcement in intact marriage, but is after divorce, partly for the reason that Kate
So
said.
in part of why I don't want to talk about it is because I do mean that mainly as to be provocative and particularly with things changing rather than take it on. But in order to be provocative, I need to understand what I'm trying to provoke a little bit more. So let me just say a couple other things real quickly. First, about muscle mediation, and this has to do with how I in confidentiality, how I wrote the paper, which was fast. If you saw my line at the end, like, I'm out of time, fill in the gap for me, you know that I did. I like confidentiality in mediation. I want that to be, but when you go further down the funnel and you become a parenting coordinator, I don't like having to make decisions. So I'm a parenting coordinator, I have the decision-making thing. I say, I'm about to make a decision that you've contracted with me to let me make. Would you like to agree first? So then I do what people call muscle mediation, but I want mediation to be a really parentally determined, confidential process that really is all about helping parents to agree. And then just the last thing that I wanted to say, because it's before the break, I'm an advocate for ALI, and there was another question about for approximation, and there's another question about what's the justification? I think you asked the question about what's the justification. I'm an advocate for anything that's going to reduce conflict. I think clear rules are going to reduce conflict. I think alternative dispute resolution is going to reduce conflict. Somebody mentioned the child support laws. I was trying to mediate before, in the era prior to child support schedules. And mediating child support was hairy, right? And then all of a sudden you have schedules, and all of a sudden the conflict went away. They're saying a determinate standard reduces conflict. Yeah, absolutely. And then one last thing I just wanted to say for you, Nancy, is that my idea of contracts, maybe that would be a step for same-sex parents. If they could have contracts, we contract to raise this child together. It's an enforceable contract, kind of a step towards the registration idea, but it's more private. So.
Well, and I will say that if you look at any of the material put out by advocacy organizations for LGBT families, they all say that the couples should use alternative dispute resolution. I mean, that the fear of a hostile court means that going through either collaborative law or through some form of ADR is a way to have respect for the families that the couples have created. And so I think, those things are very connected.
Yeah.
It's just that if one parent has legal power, she's not going to do that because she knows she can go to court and get rid of the other parent. But, all of the organizations will say you shouldn't do that and go through alternative dispute resolution with someone who understands what your family is.
And that's my experience with mediating with same-sex couples. And also just on your point in the contract idea, so one of my current graduate students is pregnant in Virginia. And it's a same-sex relationship. She's going to drive to Washington to have her baby, right? Yeah, just so she can get the birth certificate that you were talking about.
But she
That's
can now do a second parent adoption in the District of Columbia because we just changed the statute so that birth in the District of Columbia confers jurisdiction on the District of Columbia courts to do adoptions. All the kids from, all the moms from North Carolina, if they have any they're the ones who are gonna, Virginia and North Carolina.
But it's also partly, what a crazy situation that you're about to give birth and you got to drive 2 hours to DC to give birth. So that's why we need alternatives like maybe contracts or whatever.
Just make sure she does a second parent adoption too, because there's this issue of having it in validity in other states. Trust
Yes,
me. If you're legal law,
true.
so if your affair doesn't go that far.
Bob.
A quick observation. Actually, two. First, even with contracts, you've got to answer the question, how are they going to be enforced? I mean, one of the great creations of law is even with strangers, apart from intimates. I can make deals that, at least in our country, for better or worse to some extent, you can get enforced. There are parts of the world where there really isn't a rule of law and where companies, it's not as if companies still don't do joint ventures, but they worry like hell because there's no method of dispute resolution other than negotiation or politics or whatever, okay? So I think you've got to answer the question, ultimately, what can someone do if they say, she's breaking her promise? I want to make her keep her promise. Second, you've got an issue of what are the limits of private ordering. I mean, in child-related materials, for example, I mean, family law teachers teach about this all the time. Would you permit 22-year-olds to sign a prenuptial agreement where the husband promises the wife, you can have exclusive custody? Or vice versa, whatever. And I think that as a matter of policy, public policy, on the one hand, most of us in this room really love the idea of private ordering and having parents be able to decide, but people get a little queasy if it's a very long-term contract. And you necessarily can go off and get it enforced because people's lives change, their own ability for foresight is different, et cetera. So I think that as someone who is a big advocate of private ordering, where at the time of the divorce, I'm prepared to let them make a deal and enforce it. The scope of prenups, I get a little more worried, particularly with respect, when they're young people, and it's with respect to children they haven't had yet, who knows. So I think I just point out to you that in terms of I think it's terrific that you've put this on the table, but in terms of the themes, there are really three big points. The first one is Buffy's, okay? And that is, what the law's posture is, if you exit from this formal relationship, we'll sort things out. We'll help you sort things out. You can have access to dispute resolution, but if you're in the middle of it, we're not. Even, by the way, there, with respect to some financial matters, if it's spending too much from a trust or other ways that you can set up structures, husbands and wives can sue each other, even during an ongoing marriage, with respect to some financial kinds of things. Not support, but some other stuff. And the second point is, what's going to be the backup in terms of ultimate enforcement? And the third is, what limits, if any, do you want to have? And I think all of those are kind of serious questions.
So I was scribbling, and then I'm going to stop because everybody needs to go. So I'm scribbling not because I have answers to this, because I'm scribbling because great ideas, and I'm writing them down. I want to go and look. This is kind of things I haven't learned about. Or we just tussled around in the hotel room, and so I got to figure this stuff out. But I do want to say something about the law and concern with the law is that you're so afraid. Whoa, what's going to happen if the law gets out of it? But young people today are doing their best in relationships to get away from the law. That's why in Australia people aren't getting married. That's why young people are cohabiting, saying marriage is just a piece of paper. They're trying to get away from the law. And in this area, the law really hasn't led. The law has really, really followed. I use terms like time sharing and decision making in joint custody, which wasn't on the books in Virginia when I was writing mediation agreements. So people are wanting to, I think, to live their lives actually outside of too much influence of the law. Maybe that's a bad thing in some areas, but maybe there's a message that's there too.
Until they have a falling out with their partner and they don't have any property or they don't have any support or then they want to turn to the law to assist them, right? And we think that's appropriate.
With their property, and there's actually fascinating stuff that on kind of bringing back common law marriage in places like New Zealand. New Zealand, you're married, if you cohabit for 2 years, you're legally married, essentially. But property and so on, but I'm not sure how good a job the law has been doing with kids. Property is a different thing.
So Australia is a great example of this too, that people are not marrying, but then they have de facto recognition. And the reason that's there is to a large extent, exactly what I said, so that there is actually a regime, just like the regime we have for, at the time of divorce, to decide what to do about property, support, and all that kind of stuff. So sort of want to get away from it.
Yeah.
It's very hard to get away from the law, trust me.
There's a difference between people wanting to say, she and I want to decide what norms are going to govern our relationship. And to a substantial degree, the law gives a lot of autonomy in that regard. Where if we can agree, they may even enforce them. They may. There can be limits. But a second issue is, although you want autonomy in your norms, what do you want, self-help if it breaks down? Or do you want no remedy? It's a separate question because a lot of the young people say, I want to get beyond the law. What they really are saying, we want to create our own norms for what is a fair way to deal with money or
And have the law
children.
enforce them.
I'm sorry?
And have the law enforce them.
And have a law enforcement.
And I actually, in the end, I don't think we really disagree, because that's where I come to, if you agree, that's where I want the law to honor it. It's, if you disagree, I'm not trying to get out of the business, except that asking the question, I think, creates some other interesting questions that may lead to more practical things. Speaking of practical, Kate, tell me to be quiet.
I'm not telling you to be quiet. There are some people who need to go, and I'm tempted to turn to Buffy for closing, thank you. No.
Thank you. To everyone, this has been really terrific.
This has been fabulous. You all have played your part and then some, and it's just been really great to have you all here. Thank you.
Thank you.
Thank you.